Hi everyone, my name is Dr. Thomas Coggin and I'm a senior lecturer here at the University of the Witwatersrand, and I teach and research in the area of property law. I'm coming to you today because I read an opinion piece early this morning by Arjun Basson in the News 24, and in that piece Basson reflects on the role of President Ramaphosa, or the lack thereof, in terms of trying to stop the imposition of tariffs by the United States on South Africa. These tariffs came into effect today. And one of the reasons Basson gives is the Expropriation Act, the passing of the new Expropriation Act. So I'm going to be responding to that. The new Expropriation Act was signed into law earlier this year, and it was designed to replicate or to speak to the dictates in our Constitution, right, in Section 25 of the Constitution. The previous act was signed in 1975, and that act adopted a very market value oriented approach to expropriation, right? So in other words, if the state was going to expropriate your property, as compensation for that, you would get what the prevailing market value was of the property, right? Under our Constitution, however, right, so this came into effect in 1994 or 1996. Under the Constitution, market value is only one consideration that is taken into account when determining compensation, right? There are many other factors that need to be taken into account when determining the amount that is paid. And these factors include the current or historical use of the property, and also the current and historical acquisition of the property, all right? So the new act changes how compensation is determined, all right? And it does so in a way which now reflects the Constitution, which I think is correct, but more than correct, it's necessary to do, right? Our Constitution is the supreme law, and all law is subject to the Constitution. And arguably, one could say that the new Expropriation Act was actually signed into law 30 years too late. All right. Arguably, we could say that the Expropriation Act, the previous, the 1975 Act, was out of step, and it was out of step with what the Constitution provided for. Now, make no mistake, right? There's a lot of fear, right? There are a lot of misconceptions about the Act, and I'm going to speak to perhaps the principal fear, which is the provision of nil compensation. But first, I'm going to speak to two procedural safeguards in the Act, which I think are significant and important to remember, because they demonstrate how the Act is not designed to facilitate the arbitrary acquisition of property by the state, right? It's rather, it's designed to facilitate what we could maybe call the just and equitable acquisition of property by the state in terms of expropriation. So the first safeguard to note is that before an expropriation can take place, right, before the state, in other words, acquires your property unilaterally, all right, there must be an agreement on compensation, right? Either an agreement on compensation or a court must have made a determination on compensation. So what this means, for example, is, let's say you have got a piece of land, all right, and let's say the state needs that land in order to facilitate the expansion of a train system, for example, right? In order to do so, it cannot be kept back by the fact that you want the maximum value for your property, right? It needs that property for a public purpose and in the public interest. Okay, so because of that, all right, it would come to you and say, we intend to expropriate your property, right? And let's say, for example, they offer a value that is significantly below what the market value is of your property, right? The first safeguard in the Act allows you to challenge that in court, to challenge that amount. It also allows you you and the state to go for mediation to determine what that amount is, all right? And only once there is an agreement or an order as to what that compensation is, can the expropriation then continue, right? So that's the first safeguard. And given the fact that this will take a period of time to do, right, you know, it's likely that the outcome will probably be quite fair in the end, okay? The second safeguard is a fairly bizarre provision in the Act, right? And the provision says that before an expropriation takes place, right, so this is even before the state deciding to acquire your property by expropriation, before that takes place, the state must attempt to purchase that property on the open market, right? Which is bizarre because that goes against the whole principle of expropriation, right? Expropriation is not about you consenting to the acquisition, right? Expropriation is a unilateral acquisition of ownership, right? But nevertheless, there is the safeguard which says that the state must take all reasonable measures to purchase the property on the open market. Now, given the fact that expropriation is quite difficult to begin with, right, I project that the state or functionaries within the state are likely to just attempt to purchase a property on the open market first, because it's going to save them a lot of time, effort, and money in doing so. So that's the second safeguard. Now let's talk about the major fear, right? The major fear is this provision of nil compensation. Now, nil compensation includes various specific instances, but it's not limited to those instances. And those instances include where you are holding land purely for the purposes of speculation, right? So you say you purchase a piece of property and you anticipate that in 10 years' time, this property is going to be enormously more valuable than what it was before when you bought it, right? And during that time, you don't use the property at all. You are only holding that property because you want to benefit from its market appreciation. In such an instance, nil compensation may be offered. Another instance is where property has been abandoned or is not being used, right? I'll give you an example of this. There was a case decided about 3 or 4 years ago in which the Ekurhuleni Metropolitan Municipality offered nil compensation to the owner of a property who had effectively just abandoned it, right? This property was an old abandoned mine, all right? It was owned by essentially a shell company, okay? And the owner had not paid their rates and taxes, so much so that they owed thousands of rands to the municipality. But also, the land was actually toxic, right? The owner had not complied with their environmental obligations to rehabilitate the land, okay? The city also wanted to use the land for social housing. Now, in such an instance, that is an example of where no compensation may be provided, right? And I think it's important to bear that in mind because, you know, land is important. It's an important resource, all right? And the state has got a responsibility, I think, to ensure that land is being used productively, right? Otherwise, land scarcity becomes an issue. That said, again, it's important to remember, vital to remember, that there are significant safeguards within the Act for an owner to challenge, for example, an awarding of nil compensation. And given the fact that there are so many procedural safeguards, I project that in fact expropriation will not be a particularly strong feature of the South African landscape, and that in all likelihood, if a state functionary wishes to acquire land, it is probably going to do so on the open market first.